All right, everyone, for this week's video for week 10, we're going to go over the main concepts from chapter 5 and 6 from Thinking Like a Lawyer. It's mainly going to focus on the burden of proof, the different biases, how we use deduction, and then a little bit of policy analysis as well. So, first, burden of proof. It came up a lot. It definitely a main idea, right, from the other videos and whatnot, and discussions. There are two main parts to the burden of proof. The first is the burden of production, which means presenting enough evidence that a reasonable jury could actually consider your claim, right? And then the second is the burden of persuasion, which is about convincing the jury of your version of the facts. An important thing to note from all of that is that your evidence is only as strong as your facts, and if your facts are wrong, then your evidence basically loses all value, which makes sense. So as a lawyer, you kind of have to be careful about how you identify and present facts, right? There's also a lot of different ways to strengthen your argument, focusing on your credibility of the evidence, the amount of evidence you have, and kind of how well it all fits together. So once again, just kind of re-saying what I just said, just format it good, basically. Then we talk a little bit about presumptions, which is basically when the law assumes something is true under certain conditions. And you can definitely use those presumptions to their advantages when making your arguments, right? Take any advantage you can, right? Then, of course, there comes bias, right? Plays a big role in legal reasoning. First one is availability bias, where people rely too much on information that is easy to remember. Another is an anchoring effect, which is when your first impression influences your judgment. That's why opening statements are very important in trial cases. And then there is hindsight bias, where people think an outcome was predictable after it already happened, which is very common in any situation, right? These mainly matter because they can affect how juries interpret evidence. So you have to be very aware of this and try to account for them in your arguments and how you present yourself, right? So, getting more into chapter 5, it's kind of about how we kind of apply the law to the facts, right? Basically the foundation of this class, right? Two main methods for doing this: deduction and analogy. Deduction is the more dominant and more common method. It works through the syllogism method. Start with the rule, apply it to the facts, then reach a conclusion, right? But something important is that deduction isn't always straightforward. It can be indeterminate, meaning that the facts don't always clearly fit into the rule. So you have to add a little interpretation and be a little careful about your execution, right? Second method is analogy, right? That's just basically comparing one case to another. If the facts of two cases are similar, then the outcome should also be similar. This is very important in case law. It's also like a common law concept as well. And it's just a lot of connections there that are helpful and advantageous if you decide to use them. Then we got into the difference between rules and policies. Rules are based on past decisions and are more fixed. Policies, on the other hand, focus on future consequences, and it's kind of more of a in the present kind of process. And courts have to balance both of these when making decisions, obviously. Then courts change case law over time. That's kind of just it. I mean, limiting a case to specific facts, exceptions, legal, whatever, fully overruling previous decisions. The court is a very alive process. It's not just a very fixed process. That's why it makes it so interesting, I guess, if you're like that kind of thing. Then chapter 6, policy analysis, right? Main idea of that is basically every legal dispute involves a conflict between competing parties. In constitutional law, there's a conflict between federal power and state power, and the analysis is just about identifying which policies support each side. Then we looked at paternalism, focusing on protecting weaker groups, natural laws, universal moral principles, legal positivism, laws created by society. Then we got into policy synthesis, which means combining different policies to make a stronger argument. Policy application, where courts decide cases based on the outcome that will create the overall benefit. It's very I don't remember that word, but it's like that big word that is important. We might have to know that. I can't remember, but that like I don't remember. I need to study a little bit more, probably. Basically, to conclude this whole thing, legal reasoning is just not about applying rules in a simple way. It just involves in how you interpret the facts, being aware of the biases, using both deduction and analogy, and balancing different policies. Just, we live in the real world, expect things to not go exactly the way you want them to go, and just, take everything you hear with a grain of salt or everything that you present with a grain of salt because people can interpret them in different ways. So that's about it.